Good afternoon, everyone. My research paper talked about avoiding litigation after terminating an employee. My executive summary covers or states that this research paper discusses how school districts has experienced an increase in litigation. It also recommends ways in which human resource administrators can avoid or reduce liability in the workplace. The research draws attention to educating human resource administrators, principals, teachers, and other staff members. Updates should be reviewed annually and made to school policies and procedures. This paper also discusses how most litigations in human resource management deals with civil law, which embraces many areas, including contracts, wills and estates, corporate law, divorce, and torts. Human resource administrators are most vulnerable in lawsuits dealing with contracts and torts. Below, you will find a list of questions and recommendations within the executive summary to help avoid litigation. The first question I'll ask, is the employee involved with union activity or covered by a collective bargaining agreement? Does the employee have a disability or medical condition? If this is the case, has the employee been offered a reasonable accommodation or has been advised of their rights under the Family and Medical Leave Act? Does the termination violate law or state law or public policy, such as firing employees for attending jury duty, filing a workers' compensation claim, or refusing to engage in an illegal act? Or is there any inference or retaliation raised by the termination? For instance, has the employee recently filed a charge or otherwise complained of discrimination or harassment? And just some tips to think about to avoid litigation as well is investigate and find out what happened. This can be done by talking to other employees, reviewing records such as time cards, absentee reports, medical excuses, etc. After reviewing these records, consider if the employee would benefit from a particular training. Conduct a due process interview. Everyone deserves the right to due process. Allow the employee a reasonable opportunity to share their side of the story. This may help the employer learn additional facts worth looking further into. This will increase the perception of fairness toward the employee if a jury is ever asked to decide the merits of a claim. Document, document, document. I say again, document. Documentation. Employers must stick to the facts. Document the reasons for the termination decision while providing specific examples. These documentations must be consistent with company policies. Nothing should be discussed that should be construed as a personal opinion. Documentation could be viewed by a jury. And lastly, be consistent. Before imposing any type of discipline, remember, you are setting a precedent for similar offenses in the future. If one person is suspended for a day for being late and another person commits the same infraction and does not suffer any consequences, ask yourself, how would this look to a jury? Thank you. I hope you enjoy.